Could be like that. Well, good evening, all, and especially I convey my congratulations and thanks for the selecting me as a best speaker on the August evening of today's organizers, that is Legal Expatiate and Faculty of Law, Jagran, Lakecity University, Bhopal, third anniversary celebrations. And it's very fortunate for me because in last two national seminars, I was invited by the Legal Expatiate, where I delivered my lecture on different subjects. But it is a fortunate again to be the third time as one of the resource person of today's evening opening ceremony. It is a fortunate for me. I must thanks and I must pray my parents because they gave me a good opportunity to stand before all of you. Today's topic, in fact, actually, the organizers guided me for contesting criminal matters. The contesting criminal matters, in fact, actually covers with different subjects. That is criminal matters, litigation perspective, kinds of criminal matters, how to start from scratch if a criminal matter comes to you, how to file FIR, how to select jurisdiction, and how to calculate court fee, how to file matter e-filing, overview of the procedure after filing, and procedure to demand certified copy, procedure of preparing grounds and filing of appeal. Well, most of the viewers might be related to seniors, or most of the people, or some of the people very juniors, or whoever it may be on the screen. I am a little person before all of you. I have some dare enough to speak something before all luminaries who are on the screen. Though I have finished my 32 years experience as an advocate in various from local to up to High Court, even appearing before the Supreme Court, still I feel that I do not know anything because I am a learner. I am learning. I learn, I will be learning, because the philosophy of the advocate is always he should feel that and he must feel that. Always he says, one must say that he is a student every time. It indicates that the knowledge is a divine, a knowledge is a power, knowledge is ethics, knowledge is a great weapon, especially for a law student or law graduate or an advocate. One should always feel that they are always students till our last breath. Patience is more important. Anxiety to know something is important. Aggression should reduce. Patience to receive the information from the client is more important. Patience to invite your client with the cheerful movement is also more important. And the great heart to receive the crushed feeling of the client who would like to appear before you or who would like to enter into your chamber. These are all the cardinal principles to stand as the best advocate, or to become the best advocate, or to stand as a best advocate in the field of this judiciary. Well, my dear friends, in a criminal system, you all know very well, the ingredients or the constitution or the elements of the crime is, you know pretty well, there are different elements to constitute a crime. And we can say what is meant by crime, how we can classify the crime, how we can define the crime, that you already read from your books or you might have read from the books. But in practical, you remember, always one should feel and always we should think that the knowledge which we read from our law studies or law books, though it is applicable before the court and though it has to be applied before the court for argument's sake or something, the practical knowledge is quite different from the bookish knowledge. Why I am saying all these things? You might have read the definition of 300 or 299 IPC or 302 IPC or 304A IPC or 337 IPC, 338 IPC or 323, which relates to HUT, or 325 aggravation or 326 grievous, All these things, all definitions are definitely consist in the book, which you can easily read and which you can easily speak. But whereas if it comes up for the practical purpose, what I would like to say before all of you is, for example, let us take it how we can classify the crimes and how we can divide the crimes. First of all, I would like to say that cognizable offense and non-cognizable offense. What is offense? Let us see. What is offense? Offense which is forbidden by law is called an offense. The thing or the criminal act which is forbidden by various criminal laws. And again, we have to see what is the forbidden, what is non-forbidden. The law which is prohibited by the thing which is prohibited, the offense which is prohibited by the law is called an offense. So therefore, I can say, or we can feel that we can read as that the crime means which is against to the society, which is forbidden by an act of law, or which is forbidden or prohibited by the law is called an offense. Offenses can be classified. Offenses relates to property, offenses relates to human body, and offenses relates to the society, or offenses relates to the properties, or offenses against to the government, and offenses relating to the NDPS, or offenses relating to the press and print, offenses relating to the information technology, offenses relating to the negotiable instrument. Like that, we can classify and we can say that different types and different varieties of laws which pertains to the subject of criminology. Now let us see who is criminal and what is crime, how it is classified, and what are the classification of crimes that we can see. A person committed an offense is called a criminal. A person who committed an offense is called a criminal. And the person who is liable to be punished as a criminal or is called alternatively accused. A person who is facing accusation of the crime is called an accused. And now the offenses can be classified like this: cognizable offense and a non-cognizable offense. What is cognizable offense and what is non-cognizable offense? The cognizable offense speaks that the investigative officer, the police officer, or the person who investigates the case, without permission of the concerned magistrate, he can take up the investigation, he can conduct the investigation, and he can take the person into the custody. That is called a cognizable. What is cognizable? Let us see simply. A person can be arrested without warrant or without permission from the court. Simply, you can write like that. A person can be arrested without permission by the court or from the competent magistrate, suo motu, or voluntarily or personally, if the police officer feels that the arrest is required without permission or without taking of any request from the competent magistrate. In a cognizable offense, the investigative officer can or may arrest the particular delinquent or accused in the particular alleged offense which is said to have been committed by that particular accused. Say, for example, in 302 IPC case, it is a murder case, wherein the punishment is a capital punishment is there, or life imprisonment, or capital punishment, or alternatively the hang. So in this particular case, if a police officer receives a particular information with regard to the 302 IPC matter, if a person approaches the police officer stating that A committed a murder against a particular person, then because of that reason B died. Because A hit with some axe, or A hit with a complicated weapon or something, because of that reason B died. Then B relation or known person, or the person who had knowledge, or the person who have knowledge with regard to the particular commission, that gentleman or the particular person can approach the police officer directly. The police officer, as and when receives such an information about the commission of the offense, the police officer has to reduce the same into the writing, and he has to record the statement of the particular individual. Suppose if the person who want to submit a report before the particular competent, later I'll explain about the competence and all these things. Let us see the very starting point which I would like to say is, when an offense is committed, when offense knowledge is known to a particular person, their family members alone need not come to the police station. A person who have knowledge, such gentlemen can approach before the nearest police station, or where the offense committed, where the limits of the where the police or the jurisdiction of the concerned police station is having to entertain or to take up the complaint from a particular informant who knows that particular commission of offense said to have been committed by some individual. The police officer has to receive either written report, or if the gentleman intends to give a verbal information, that has to be reduced into the writing, and after recording of that information, the police officer has to explain the same, and he has to be explained the same into understandable language, and later he has to obtain the signature of the informant or thumb impression of the informant. That would be called as a first information report complaint. This is the first and foremost important, the foundation piece of commencement of the investigation step in the criminal investigation system. So therefore, what I wish to say before all of you is, a cognizable offense, as I already stated, that without warrant a police officer can arrest, whereas a non-cognizable offense. What is non-cognizable offense? A police officer cannot arrest or cannot take any sort of action without permission of the competent magistrate who is having jurisdiction to try such an offense. Say, for example, defamation, 500 IPC. When matter is going to be placed before the concerned police officer stating that, sir, so-and-so person or A defamed me and circulated about my character and defamed the situation. People are, they have knowledge about this, saying that I have committed this much of mistakes and all this because of such a propagation or a bad propagation. My entire reputation has been damaged. Therefore, kindly have my complaint and kindly take it for the commencement of the investigation. In such a circumstances, because it is a non-cognizable offense defined in IPC and CRPC as well as, therefore the police officer has no right to take up any sort of examination, but at least the worst, the police officer can receive that information and he can put into writing into the general diary. Always the police has certain important books in each states are having different names and styles. That is called general diary. In general diary, any information which is being regularly rotated or commenced or executed by the police officers, the concerned station house officer has to reduce into the writing from time to time and minute to minute and hour to hour. That is called a general diary information. In a non-cognizable offense, the police officer or station house officer or person who is in charge of the concerned police station, they can receive the complaint and they can put it into the writing, into the general diary, but certainly they will refer the same to approach, and they will advise the concerned complainant to approach before the competent criminal court to take up for the necessary direction for the investigation and all these things. So therefore, in this particular case, we have discussed that cognizable and non-cognizable offenses. So cognizable offenses, without warrant, the police officer can arrest the accused, and in non-cognizable offense, a police officer cannot arrest the particular accused. So therefore, these are the two classifications in cognizable and non-cognizable. And whereas, and cognizable also, simply we can say that the punishment up to beyond punishment of 3 years can be classified as a cognizable, and below 3, that is called up to 2 to 3 years, can be classified and can be said as non-cognizable. And now the second phase of the classification of offense is, that is bailable and non-bailable. As you know, 436 of Criminal Procedure Code deals about the bailable offenses, and 437 CRPC deals with non-bailable offenses. Well, gentlemen, 436 CRPC, a bail is a sine qua non, a granting of bail is a right for the accused. Automatically, the court has to grant the bail in 436 CRPC covered offenses. Whereas 437 CRPC offenses, that is non-bailable offenses, under which, without affording an opportunity to the public prosecutor, a court cannot grant bail. Under some circumstances, the court may or can refuse the bail in non-bailable cases, which would affect the interest of the larger interest of the society. So, however, as we know all, kindly note it, this is more important judgment, Arnesh Kumar versus State of Bihar. Arnesh Kumar versus State of Bihar is a classical judgment wherein Honorable Supreme Court, that is Apex Court, stated that when punishment is prescribed up to 7 years, the 41A CRPC notice shall be and has to be issued to the concerned accused persons, and the notice under 41A CRPC is a mandatory. So therefore, in that particular context, when punishment is prescribed up to 7 years, now accused, the person who is shown as an accused, the person who is described as an accused, that accused has got right to take 41A CRPC notice, under which he can submit his self-bond, or he can submit his some guarantee to appear before the police or before the court, as and when the honorable court calls him for his appearance. So in that particular circumstances, the station house officer or the concerned sub-inspector of police has to issue a 41A CRPC notice when offense fallen under the category of up to 7 years punishment, as per the judgment pronounced by, or as per the case decided by the Arnesh Kumar versus State of Bihar. And another important point is, as I have to say that the laws have to be classified like this: substantive laws and procedural laws. Substantive laws deals with the rights and liabilities of the parties, that is either accused or complainant, because now we are dealing and discussing about the criminal procedure system and criminal filing system, and what are the FIR, what is FIR, what is meant by FIR, how the FIR has to be filed, and all these things, the classification of offense, all these things now we are dealing. So therefore, I am particularly confined to this particular criminal investigation or criminal filing or criminal trial system, which I would like to, share my views before all of you. So now let us see. I myself posing a question, or you have to put a one question, that what is substantive law or what are the procedural law? The substantive law, for example, that is Indian Penal Code, is a substantive law. Indian Penal Code says, if you commit this offense, you are liable for punishment like this. Say, for example, 304A IPC, which deals about the rash and negligent manner under which a person committed an accident. During the course of that accident, if a person dies, then 304A comes into play, under which the particular driver who committed or who's said to have been committed that offense is liable for punishment. Say, for example, 304A IPC. Likewise, 323 and 324 IPC. Say, for example, 323 IPC, it is a hurt. It is a simple hurt. If a person receives, suppose if A slaps B, it amounts to hurt. But doesn't mean that can we go and approach before the concerned police station and all these things. It depends upon the circumstances. If he receives hurt, in that during course of receiving that hurt situation, if he receives any bleeding injury, or if he receives any, that the particular accused who bet that fellow, whether he used any offensive item or any other offensive article, and those are all aspects which we have to see in the practical knowledge. But whereas in a theory article, if I say an example, very easy for us, 304A. A died, B is the driver, because of the rash and negligent driving driven by the driver. A died in that accident. While B, the driver, was driving his jeep, he hit that particular deceased person. Because of that accident, that person shot dead. And in that particular context, how we have to file, what is the way, how we should represent before the police. The family members, they don't have any knowledge about the occurrence of the offense because they are not the eyewitnesses to the case. Likewise, a person who witnessed that particular incident, he has come forward to give the report, but because of the police harassment in a practical way, or all the way because the person, if he intends to submit, or if he intends to submit any complaint before the police may call me several times, and they should take me to the police station, or they should take me to the court, and all these things. Because of that fear, sometimes the real witnesses also may not come forward to lodge the report. Then what would be the way for police? Nowadays, the technology totally developed. In everywhere, maximum technology is being utilized by the police for the proving of the guilt against the particular accused. Say, for example, in recent times, YS Avinash Reddy bail application you might have heard, because it went up from local to, that is a famous MP died in that particular case, but we do not know the facts because God knows everything. But as can be seen from the daily reportings into the different journals, we can say that in YS Vivekananda Reddy murder case, and this Avinash Reddy was shown and given as one of the accused in that particular case, and CBI, and because of that reason, though Mr. Dastagiri, who himself turned into a approver in that particular 302 IPC case, that because of the statement given by the approver in that particular 302 IPC case, which relates to the then MP who is no more, that is YS Vivekananda Reddy of Kadapa, who represented the Kadapa member of parliament seat. His daughter Sunita Reddy, now she is fighting, and she is saying that because this Avinash Reddy is the responsible. We do not know who is responsible, who is not responsible. For a latest illustration, I would like to give like this, but I can't say that he is the responsible, or he is not the responsible, or she is the responsible, or somebody is the responsible, because the court has to say all these things. Now I am restrained to speak all these things. But the point is, it is a great research for every advocate. Even Raguramakrishna Raju versus State of Andhra Pradesh case also, that is also one of the great example for the whether in Raguramakrishna Raju versus State of Andhra Pradesh case, where the Lordship of Andhra Pradesh High Court as well as in the Supreme Court also, they stated that even without approaching the Sessions Court, aggrieved or the victim can directly approach the High Court of Judicature for an anticipatory bail. That is the special dicta decided by the Supreme Court as well as the High Court of Andhra Pradesh. So why I am saying is, in YS Avinash, this YS Vivekananda Reddy murder case also, this CBI alleged that YS Avinash Reddy is the responsible. How the CBI stated like that, because of Google takeout information, they have collected the all material by what time and where, while the offense was committed, where was Mr. Avinash Reddy, where his presence was available, how he was present, whether he was present very near the offensive place or not. All these information was collected from the Google takeout. So this is the great example in an Indian judiciary or in an Indian investigation system. A person, even the eyewitness was not available, nobody can escape from that particular scene. So this is one of the example. One can understand the situation of the Indian investigation system and Indian law system. Therefore, I can say, my dear friends, in Raguramakrishna Raju versus State of Andhra Pradesh case, the Honorable Apex Court as well as Andhra Pradesh High Court categorically stated that an anticipatory bail can be moved before the High Court of Judicature under Section 482 read with the other criminal procedure code system without approaching the Sessions Court. There is a feeling in every advocate mind whether without approaching before the sessions court of the concerned district, can we approach before the High Court of Judicature in the respective states for the getting of anticipatory bail? For the answer is Raghuram Krishnam Raju versus State of Andhra Pradesh case is a classic example to that particular query. And the second aspect is how the investigation system, and even without the presence of the, why I am saying all these things, in a 304A case, I'm again going back, in a 304A accident case, nobody did not witness the incident, but the cameras, which is always fixed in the particular area. You may put one question, sir, no cameras are there. What could be the next position? Even in one judgment, even tire marks in the particular area also is one of the important crucial point to find out the crime vehicle. In my career, now I have finished my 31 years experience. Now I'm running 32 years experience. While I was in 5th year advocate, I took this challenge. Why? Because one accident was committed by some X, but that X was escaped. But police, in a brutal way, or because of the reason of political influence and all these things, they implicated a case against my client, under which I investigated and I inquired about the incident. My client stated that, sir, by that time, I was in Hyderabad, sir. With which vehicle? The very same vehicle, the police under which the crime is registered, that vehicle was available in Hyderabad, wherein the police brought that vehicle and cooked up the case. Then we have produced all the toll gate informations, all the toll gate receipts and all the toll gate cameras, clippings and all these things. Ultimately, we have proved, of course, saying is very easy, but in a execution in a practical way is quite different. It took up for me not less than 2.5 years to collect all these things, to summon the witnesses and everything. Then ultimately, I proved that the alleged innocent accused did not commit that offense. So, my dear friends, you please take care of everything while a fresh matter come to your chamber. Suppose if you are a raw junior, don't feel any shy. See, no one is an encyclopedia Britannica on this earth. You all people are analytical, ethical, perfect, loyal, royal, powerful, peaceful personalities, I believe. Why? Because everyone is definitely a raw person when he intends to start his practice on the first day. But doesn't mean that he won't succeed. He would succeed if he works hard. So in this particular case, what I would like to say is the jurisdiction of the courts. How the jurisdiction can be decided. Say, for example, an accident was occurred within the limits of a police station, and the vehicle passed away, and the vehicle was ultimately found and identified in the next district, and a communication went on, and that was caught hold. And even in that particular area also, on that information, even though the police officer has no power, he can register a 0 FIR saying that, knowing the information, because in a police set, the communication was circulated by the entire police, or the police will circulate the entire information to the entire police. Say, for example, in A police station area, accident was committed by B driver, but he escaped from that particular place, and he left the district, and he entered into the next district. And in that particular district, when the police officer who received that communication, he has got every right to register a 0 FIR stating that I received an information through police set information saying that so-and-so offense was committed at so-and-so police station, and therefore I found this particular vehicle relates to the so-and-so crime. Therefore, I am registering a 0 FIR saying that so and so driver committed so and so, and a confessional statement given by the driver also, the particular police officer can write a zero FIR. That is called a zero FIR. Zero FIR means the police officer who has knowledge about the information, he can register the zero FIR. That zero FIR along with that vehicle, that crime vehicle, he can transfer the same from his police station to the police station where originally the offense was committed, and that is called as the transferor police station. The transferor FIR goes to the transferring police station, means where the real offense was committed. Then the police station in whose jurisdiction the original accident was committed, that police officer, after taking this zero FIR, he starts to write this particular FIR at fresh, saying that so and so zero FIR received from so and so police station with a crime vehicle where the accused committed so and so offense. Because of that reason, so and so person died in the particular accident. So in that particular circumstances, the original jurisdiction police officer, he would register the crime against that particular driver who committed the offense, and he will start his investigation. So this is the way how the jurisdiction, how can we fix the jurisdiction? Say for example, in a 379 IPC case, it is a theft case. Say for example, our friends are, suppose our neighbors went to the America, and say for example, I am staying in Mumbai. My neighbors went to America, informing that brother or bhaiya, I went to America. We are going to America, and like this they represent. Okay, right. Then after some time, an offense was committed my neighbor's house, stating that some robbery was committed by some unknown culprits. Then that information was received by that particular American people, that person who left to America, and they communicated same thing or something. But the very first information is received by me or identified by me. That's mean I have a right to go to the police station and I can lodge a complaint before the police, even without waiting for the real victim people. I can lodge the complaint, and that complaint has to be received by the police officials. In that particular case, I would be the first informant to the particular offense. Then the police will commence the investigation, and after receiving the FIR from me, which is going to be duly signed by me, and the police will start the investigation. And after recording my statement and the FIR and all these things, the concerned FIR will go to the court where the police station is situated, or the court which is having our superior power or administration of justice power over the police station. That police officer would send the FIR to the particular court, and he will send, he sends all the FIR other copies to all his officials. So in that particular case, after sending the FIR, the investigative officer starts the investigation always, and he always visits the particular scene of offense, that is the house where the offense was committed. And in that particular case, for getting of fingerprints and all these things, the clues team will, the clues team will be bring by the particular police. It will be called by the police officials, and the clues team will come and find out the real system and any fingerprints which are available, or the offensive items which were said to have been left over by the particular accused. Then clues team will find out. Then the investigative officer prepare the rough sketch. The area where he visited, he will draw the rough sketch. So then he will record the statement, and he will record the photographs. And nowadays he will record the videograph and all these things. And after that, he will call the even that American that America people where they reside, or they can be examined even through video conference also. They said, but in 164 CRP or 161 CRPC, they can be only recorded under any mode, but 161 CRPC statement cannot be used as a direct evidence. It can be corroborated and contradicted, and an opportunity would be given to the accused to facilitate him to challenge the evidence which is going to be recorded under 161 CRPC. The statement said to have been recorded by the police officer under section 161 CRPC, always the police officer reduced into writing, and finally in last line, I have explained the statement recorded by me to the deponent who gave this, but in 161 statement, the police officer has no right to take the signature of the person who intends to give statement to the police. This is more important, my dear friends, remember. In 161 statement, if any police officer takes, or if any police officer take any signature on the beneath of the 161 statement, that 161 statement has no evidentiary value, remember that. But whereas 164 CRPC, that is a statement which is going to be given by the victim or the person who has knowledge, who have knowledge about that particular incident, that can be recorded before the competent magistrate, or that can be recorded by the police officer in the presence of the competent personalities, or in the presence of the particular witnesses. Then that can be 164 CRPC is a different form, and 161 CRPC is a different form. And 150, I can say is, in particular, again, I'm going back, cognizable and non-cognizable. This is very, because the crucial point which I wanted to say is, in a cognizable, the police officer can take up the investigation. In a non-cognizable, what is the fate of the particular individual? In non-cognizable case, the victim or the complainant has to approach before the competent magistrate who has jurisdiction to entertain or to take up the complaint, and he has to submit his complaint under 200 CRPC coupled with 156 class 3 CRPC. 200 deals with the private complaints before the magistrate, whereas 156 class 3, a magistrate is empowered to send the complaint to the nearest police station for the investigation. So if magistrate feels that the investigation is required even in a non-cognizable case, even though the victim submits his complaint before the court, under section 156 class 3 of CRPC, the magistrate can refer that complaint which is said to have been submitted by the complainant to the concerned particular police station, and he can order and he can direct the concerned police officer or investigation officer to investigate into, to register the FIR and to investigate into if necessary. So that order would be passed in non-cognizable cases by the magistrates under section 200 and 156 clause 3 of CRPC. Even in sometimes, even in cognizable case also, even though the police officer is empowered to take your complaint, because of various reasons, police officials won't take up your complaint, and police officials won't accept your complaint, and police officers simply neglect to register the case. In such a circumstances, what we have to do, or what shall we do, and what do we do? This is important. If victim intends to file a complaint in a cognizable case, it is the duty of the police officer mandatory that he has to take up the complaint. But in another reason, the police officer does not interest to register the case, then what is the way? In that circumstances, the copy of the complaint always keep with one copy of the complaint. Advocates have to suggest their clients, or advocates who would like to file a complaint on behalf of the complainant or victim, they should take a duplicate copy with they should retain a duplicate copy with them. A original always the complainant submits original complaint to the police always, and the duplicate copy always keep with the party or retain with the party for further course of necessary action. And the duplicate copy which retains with the particular complainant or victim, that copy has to be, or that information has to be sent to the district superintendent of police, and with that you can request the competent superintendent of police and request him to take up necessary investigation according to the CRPC. In that particular aspect, the superintendent of police, if he feels that there is a point to go for the investigation, suo motu, the SP can take up the investigation, or else he can guide or direct his subordinates to go for the investigation of the case. Even after sending the case to the SP, even after SP referring the complaint to the subordinates, still the grievance is not solved. What would be the remedy? Then the victim has to approach before the competent criminal court by way of filing 200 CRPC private complaint along with necessary affidavit under rule 37 and 38 of criminal rules of practice. These are the facts. Under these circumstances, I have lodged this much of complaint on so and so date. But the concerned police officer did not take up investigation. And later I requested the SP to take up the investigation according to the CRPC. Even then SP also did not take up any investigation. So under these circumstances, the justice is required. So therefore, I am approaching before the honorable court to take up the matter for the taking of the cognizance of the case, under which if the case of the complainant is right, after taking the evidence, a oath or something from the witnesses, the honorable court, if finds that there is a point to proceed further, then they will issue summons. So this is another procedure. So my dear friends, how to file FIR? We have experience with 302 IPC case and 279 IPC case. We have discussed. I mean, 279 is a rash and negligent manner. This is the 279 and all these things. And 337, 338 relates to Act 337, 338 and 304A, and 279 IPC relates to accidents and rash and negligent acts. And 323, 324, 325, 326 relates to offenses relates to human body. And offenses relating to matrimonial disputes, 498A and 304B, specifically 304B IPC. And furthermore, 350 offense against women, 354, 354A, B, C, D, and 379 IPC. And offenses relating to the waging war, the criminal conspiracy is 120B, and 499 and 500 is related and discuss about the defamation and all these things. So these are the IPC related crimes. And now we have to see other than the IPC. Let us see. See, Narcotic Drugs and Psychotic Act, that is NDPS Act, as we know all very well, because nowadays the drug activities are rapidly growing up, and drug offenders are being arrested time to time by the concerned police, and some innocents also being arrested, and some real culprits are escaping from the calamities and all these things. So in that particular case, recently I was fortunate. I argued before the High Court of Judicature in Ranjit Singh versus State of Andhra Pradesh. Ranjit Singh versus State of Andhra Pradesh. Generally, as and when a ganja, this cannabis, this suppose finds from anyone, simply the police register the case under section 20 of NDPS case, and they send the all culprits to the they submit and they produce all the culprits before the courts. But here, the quantity of the cannabis which I found in the particular FIR, because the commercial quantity, if it is commercial quantity, then the punishment is a different, and below the commercial quantity, that punishment is a different. So in that particular case, my client arrested below the commercial quantity, but he was sent to the judicial custody, though he did not commit more than commercial quantity. So in that particular case, I argued the matter. The property involved in the seized property of cannabis relates to my client, that is Ranjit Singh. I have argued before the High Court of Judicature, stating that that is worth value of below one case. So therefore, 41A CRPC would be applicable. That I have argued. This is a reported judgment. Even my friends can see my name, that is as Dr. Majjusuri Babu, counsel for the petitioner in that particular bail application. In that, the Lordship's Court of Andhra Pradesh held that even in NDPS cases, if the punishment is prescribed to that offense up to 2 years, because it is a fallen under the category of Arnesh Kumar versus State of Bihar, where the apex court held that when the punishment is, up to 7 years imprisonment, certainly this Ranjit Kumar is entitled to get the bail. Therefore, that gentleman was released from the bail from the judicial custody. This is a classical judgment wherein the judgment is being adapted and applied and taken into consideration in various cases in a total national level. This is a fortune in my life. So in that particular case also, let us take it as an example. See, advocate must read the entire recitals of the complaint first. Suppose if you are a defense counsel, sometimes advocate represents for the complainant and sometimes advocate represents from the accused side. So two-way folded lifestyle and two-way folded duty has to be discharged by the advocate. So when we appear on behalf of the complainant, what type of measures to be taken, and when we appear on behalf of the accused, what type of defense has to be taken, that has to be always kept in the mind of the advocate. Because the dual role of the advocate always plays an important role for the success in getting or in protecting the interest of the respective claimant. Now let us see. Suppose when we appear on behalf of the complainant, naturally the victim, he always narrates certain important facts, or even sometimes the complainant represents unconnected facts to the particular case. Then you have to evaluate and you have to investigate, and the counsel who would like to take up that bundle from the complainant or from the case, how to prepare a complaint is a basic skill, and that is a drafting skill of the advocate, which is a prima facie more important. For example, in 379 IPC theft case, suppose if the value of the property does not mention by the complainant in his complaint, where is the complaint? How the police can recover that property? How the police can investigate that matter? And if the description of the property is not properly given, or else if the attached documents relates to the ornament, suppose if the ornaments purchased from a particular jewelry shop, naturally we keep always the receipts. If the receipts are not available, then that doesn't matter. That is a different aspect. That drafting skill is a different. Suppose whatever the evidence and whatever the documentary evidence and whatever the eyewitnesses available with the complainant, the drafter of the complaint must prepare all the necessary ingredients on behalf of the complainant in the manner of the first person. Always the complaint must be in the first person if the complainant intends to submit his complaint. He cannot represent as a third party complaint. Complaint always drafts by the complainant or his henchman or his follower in the first person only. It cannot be like the second person and third person style way. That style is not at all perfect. Like suppose for example, like an affidavit, how the affidavit is going to be drafted, in what manner the affidavit is going to be drafted, in that line the complaint always draft in that manner only, in second person and third person language. In a local language also, the first person language always used by the complainant in drafting a complaint. So my dear friends, when it comes up from a defense, naturally defense, you need not worry about that, because the other side will supply, the other side has to supply the necessary documents under which they depend and under which they intend to go for the continuation of the prosecution on behalf of them. Naturally, sometimes defense is easy rather than the complainant side. Why? Because naturally in India, and always the innocence is cardinal principle in the Indian judiciary system. The benefit of doubt maximum extends to the accused. The benefit of doubt always applies to the accused, and the crime or the offense or the allegation always prove beyond all reasonable doubt by the prosecution to prove the guilt against the accused. Whereas in US or in the foreign countries, it is the duty of the accused. He must prove his innocence. The complainant need not prove his case. But whereas in India, the complainant has to prove, or the complainant or the prosecution has to prove the case against the allegations or accusation against the accused. And always in Indian judicial system, the accused is always an innocent person until the guilt is proved. So therefore, the defense is very easy rather than the prosecution system. That is the thought process which is being always spoken by the all advocates, but it is not right. Always prosecution is highly problematic, and the conduction of the defense also is always a problematic. And a challengeable, complainant side also is a challengeable, and accused side is also challengeable. And both ways are a tough situation for the advocate, because the advocate must understand the case carefully. The advocate always should read the complaint carefully and witnesses and statements carefully. And the way how to conduct the simple, I would like to give a simple analysis. Prosecution side, for example, victim goes to the police station and files his either written complaint or gives his statement. Then police, if he submits a written complaint and the same ingredients incorporate into the format which is under section 156, that is called first information report, and the original report attached to that particular complaint, that is the first information report. Suppose if the witness doesn't know or the informant doesn't know with regard to the writing of the complaint, then the police officer always records the statement which the victim intends to submit the same, and that always explains into his own language, and the police officer always take the thumb impression or signature on the particular complaint. Then the investigation starts. Then with that complainant, suppose if any witnesses are available, the police officer in a cognizable case, remember in a cognizable case, the police, after registering the FIR, he records the statement under section 161 CRPC. Naturally, the complainant complaint is nothing but a replica of the 161 statement, but the replica of the 161 statement contents and recitals as well as the FIR original complaint or original statement always one and the same. Remember, this is very important, a crucial point for a criminal advocate, a defense advocate. Then, suppose if the complainant brings his witnesses by the time of presentation of his report, then the police officer always records the available witnesses statements under section 161 CRPC statement. But on that 161 CRPC statement, the police officer has no power to obtain any signature of the witness or the informant in 161 CRPC. But whereas in FIR, first information report, the signature of the informant column or the signature of the complainant column, there the complainant always signs or always puts his thumb impression if he is an illiterate person. This is the fundamental information, remember. Then all columns, you please go through once the FIR copy if you have an opportunity. Then date of offense, time of offense, place of offense, name of the informant, section of law, and all these columns are insert in the first information report of the particular police station. Then the crime number gives by the police officer on the FIR. Suppose, for example, crime number 20/23 registered on so and so. On the strength of underneath of the complaint, underneath of the FIR, after obtaining the signature or thumb impression of the complainant or informant, the police officer, after registering the FIR under section so and so, I registered as case in crime number so and so. I registered the same, and the original FIR is forwarded to the concerned magistrate, and copies are forwarded to the higher officials. This is the endorsement always endorsed by the person who registered the case or who endorsed the information on the first information report. Therefore, in that particular case also, the defense advocate always observe like this. Is there any delay in giving information? Say, for example, offense committed or offense done by the particular person on 5 days back, 6 days back, 8 days back. But logically, complainant did not approach the police station. The reasons best known to him. After 10 days or 15 days or 20 days, complainant intends to file a complaint. Then, really, if the complainant receives any injury from the act of the alleged accused, he ought to be present to the complaint in time. But he doesn't do so. Therefore, there was some doubt. So therefore, in that particular case, inordinate delay in giving information is a fatal to the prosecution case. The catena of the judgments are there. If you click in the Google, inordinate delay in giving the information to the police by the informant or complainant is a fatal to the prosecution case. This is one of the most first fundamental defense always maximum advocates takes and brings before the court. So therefore, inordinate delay in giving information or else inordinate delay in lodging report before the police is a fatal to the case. Suppose if the complainant explains the reasons for the delay, then if that delay is probable and if the delay is believable, then that is the point to be considered by the court at the time of passing of the pronouncement of the judgment or at the time of passing of the any order. That is a different aspect. But the defense always, the counsel always takes the defense that whether any delay occurred in lodging the report or whether any delay occurred in giving the information to the police. This is very cardinal principle, very first defensive point to be applied and has to be taken into consideration in the mind by the counsel who wish to go for the defense this thing. Then registration of FIR in prosecution way and defense way I am explaining. So after registration of the complaint, then after recording of the statement, the police, the investigative officer who intends to take up the investigation, he always visits the scene of offense. What is scene of offense? The place where the offense is called is scene of offense. Remember, the place where the offense is called scene of offense. So for example, accident was occurred at 10th milestone at some Bombay highway at some particular town by name, which is distance about so and so kilometers north or east or west or south to the police station. Suppose for example, Ramnagar 10th milestone right side accident was occurred. Then the investigative officer goes to that place and he visits that place. That place is called, where the offense is called, that is called scene of offense. Then the scene observes by the investigative officer. Then he prepares a rough sketch. After observation made by the police officer, he prepares scene observation sketch. That is called rough sketch of the scene of offense. So investigative officer visits the scene of offense and he prepared a rough sketch. That rough sketch is called scene observation rough sketch. Then he prepares a report. When he prepared a report, that is called scene observation report. Remember, there are 3 stages happens at that particular place. One is visits scene of offense, and number 2 is after visiting the scene of offense, he draws the rough sketch of the scene of offense, the offense where the incident, where the place where the incident is occurred, that is called scene of offense. Then after visiting the scene of offense, that observation is called as a scene observation. And in that particular case, naturally and always, the investigative officer always does like this. He prepares a rough sketch and he prepares the scene observation report. So one is rough sketch and another is scene observation report. In that particular case, always he does that activity in the presence of the independent mediator, saying that I have visited the so and so place on so and so date and visited the scene of offense and seen and observed the scene and taken the rough sketch and prepared the scene observation report in the presence of the independent mediators. Why the independent mediators are required in this particular case? If the independent mediators are not produced, are not recorded, are not mentioned in the particular report, then it vitiates. Why? Because it would go for some suspicious circumstances. Then that would be called as a table investigation. Sometimes police officers, they don't want to go to the scene of offense, and they don't want to prepare any rough sketch, and they don't want to see any scene observation area. Simply they prepare, always maximum police officers, 60%, 50% of the police officers, they prepare everything in the police station. That is called a table investigation. Remember, my dear friends, that is called table investigation. Means without going anywhere, simply creates everything, saying that I went there, I prepared this much, and I prepared that sketch, and I taken all these things. And even mediators also, they put their signature in the police station. They are called as a stock mediators. Remember, my dear friends, the mediators who always, they have to act as and when the real things happens. But here, the created and illusory mediators and arranged and set up mediators were prepared or being developed in the criminal justice system. I mean, the police administration system, they always bring some artificial or the persons who did not really witness that incident. They would like to keep them as a independent mediators. And in that particular sense, the defense advocate has to take up a very crucial, important point. In this, what I wish to advise to all my friends is, always you please, defense witness, please visit the scene of offense area, because the visiting of scene of offense area would give volumes of truth to the every advocate. That would be benefit for the succeeding of advocacy. Why? Because suppose sometimes if the mediator comes up to the court saying that I witnessed the rough sketch drawn by the police, but when you put a question like this, really by what time you went to the scene of offense? When did you start to go to the scene of offense? How many persons started from the police to visit the scene of offense? How many persons boarded in the jeep to visit the scene of offense? How many persons gathered in the scene of offense? What did you identify in the scene of offense? Who informed about the incident scene of offense? Who prepared the rough sketch at scene of offense? And who drawn the rough sketch at scene of offense? All these questions, if really if the mediator who set over produced before the court, if really doesn't witness the incident, definitely he would fail to give all these answers. Then the defense would succeed in that manner. So, my dear friends, defense always must take careful to visit the scene of offense area, and they also observe the rough sketch, and they should tally the points which are drawn by the concerned police officer. So this is scene of offense questions. So FIR questions I have given, then scene of offense questions, rough sketch questions, and other important mediators questions also I have given. And inordinate delay in lodging report and a delay in giving information report to the police, the defense points I have given. And now let us see how to cross-examine the witnesses of the prosecution. The person who filed a complaint is called the informant, or is called as a listed witness 1. And LW1 and LW2, the police officer, after recording the statements and after getting now I'm discussing about the prosecution. Now we have discussed the defense. Now I'm discussing about the prosecution. After recording the statements and after collecting the necessary material, and after collecting any incriminating material and any material objects in that case, and summarize the entire case, and prepares a charge sheet, and after enclosure, all these 161 statements, first information report, and a mediator's report, and a Panchanama report, and rough sketch, and other things, the police, they file charge sheet before the competent court, and the competent court take up the cognizance of the case and issue summons to the accused, and the accused will appear before the court, and the accused will be examined under section 251 CRPC if it is a summons case. Otherwise, in warrant case, the procedure would be followed in a different. And later on, after denial, suppose if the accused is going to be admitted the case, he will be sent to the he will be punished. But suppose if the accused denied his offense, saying that he intends to claim for a trial, then the commencement of trial will begin. Then the summons will be issued to the witnesses, that is listed witness 1, listed witness 2, listed witness 3. Now, always generally the informant would be called as LW1. Then LW1, when he comes into the witness box, then he will be called as prosecution witness 1. That is called PW1. So always the judge writes like this: LW1 examined as a PW1, his statement or FIR marked as exhibit P1. Prosecution side in criminal case, there are exhibits, the exhibits always marks like this. Prosecution examination exhibit P series, take up as a P series. Suppose if any document marks on behalf of the prosecution, exhibit P1, one document. Second document, exhibit P2. Third document, exhibit P3. Fourth document, exhibit P4. Like that, prosecution witnesses series are like this. And suppose any material object, suppose any offensive item, suppose in 324 case, a beaten with a stick, then that stick is a offensive article used by the accused during the course of commission of offense against the victim. Then the police always recovers that weapon at the instance of the accused confession statement, or after showing the necessary article by the particular victim, then that would be called as a material object. So the objects which used in the commission of crime, which were recovered by the police during the course of search and seizure procedure under 100 CRPC, then that is called 100 CRPC, that is called search and seizure procedure. So then marking would be like this: material object 1, material object 2, material object 3, like this. Suppose if the defense items intends to be produced or intends to be marked by the prosecution, then that would be marked as D series. Suppose if the court voluntarily, if the court intends to mark certain documents sumoto by the court, then X series would be marked. So, my dear friends, remember, prosecution examination, LWs, listed witnesses. If the listed witnesses comes into the witness box and if they examined by the court, they would be converted as a prosecution witnesses 1, 2, 3, 4 serial. And material objects, if any used in the commission of crimes, that material objects always marks like material object 1, material object 2, material object 3. And likewise, suppose if the court intends to mark sumoto or voluntarily, then that marks as a exhibit X series. And suppose if the defense intends to mark their portion, then that would be marked as a D series. Then coming to the examination of the witnesses, the prosecutor would examine the witness who are supposed to be examined on behalf of the prosecution. Then chief examination records by the court, which is going to be submitted by the prosecutor witness. Then chance will come to the defense. Then the defense has to read the entire 161 statement. The statement which is recorded by the police, if the witness confronts the same, that is called corroborate, that is called as it is. But beyond the statement, suppose if the witness intends to give, that is called improvements of the statement. Improvements of the statement. Say, for example, the victim stated like this. According to the original complaint, victim stated that at 7 p.m. morning, accused came to my house and he brought one stick and bet on my head and I received bleeding injury. This is a complaint given by him. Whereas in the evidence, for exaggeration of his case, if victim says accused came to my house at 8 a.m., bet with iron rod, and I received injury on my forehead. What are the improvements? Time of the offensive time, the crime time is changed, weapon used by the accused is changed, and the injury sustained by him is also changed. So remember, my dear friends, you please go through what are the recitals of the complaint consisted in the complaint said to have been submitted by the complainant. This is very, very important. So the time of offense, date of offense, recording of evidence, and the alleged recovery, if any, shown by the police, the time of recovery, or the witnesses who are said to have been present during the course of recovery, those important points always put to the cross-examination of a prosecution witness 1. That is very, very important. Suppose if the witness goes beyond the statement, that amounts to contradiction. The statement which he stated, if he doesn't speak the same before the court, and beyond that statement if he gives, then that portion of the statement you have to put like this: you have not stated before the police that at about 8 a.m. so and so person came to your home and bet with the so and so weapon and received injury on your forehead, because the version in the complaint is different and the deposition given by the witness is different. So when the deposition is different, that portion you have to put forth before the complainant, saying that you did not state before police like this. Then witness will say like this: no, I have stated like this. Then that would be recorded by the court as, it is not true to suggest that I did not state in my 161 statement that at about 8 a.m. the witness brought so and so weapon and bet with that on my forehead like this. The very same question you have to put to the investigative officer at the time of his evidence in cross-examination, saying that whether the PW1 stated like this or not. You have to put the entire question to the police officer whether the PW1 stated in his 161 statement that so and so accused came to his house at 8 a.m. with so and so weapon and bet him with so and so part. Naturally, the police officer would say that no, he did not state before me like this. Then that is called an improvement. So that improvements are very much important. Then that evidence consisted with different contradictions. So improvements of the evidence has to be confronted. Contradiction of the evidence of the witnesses have to be confronted by the defense. And those in contradictions and improvements of the evidence have to be confronted and put the questions to the investigative officer who said to have been recorded the 161 statement, because the 161 statement is a cardinal document either to contradict or to corroborate. So therefore, this has a dual value for both defense and prosecution. So in this particular case, my dear friends, you please take care while you conduct a case on behalf of the defense side, or when you intend to go for the prosecution side also, you must take more care. And coming to the appreciation of the jurisdiction point, where the offense is committed, there the jurisdiction has got. Suppose if the offense is committed at a particular place, say for example, Section 6 of the Indian Evidence Act, you please take up. Section 6 of the Indian Evidence Act is a res geste. For example, a waging war against the government was planned at Pakistan, at Lahore. Then money was transferred from Lahore to Delhi, and that money again transferred to Kashmir. And at Kashmir, some logistics, some atomic material was purchased in a Kashmir local area, and thereafter that material was sent to the Hyderabad, and later on that Hyderabad weapons were transferred to the Andhra Pradesh, and thereafter from Andhra Pradesh, from Hyderabad to some other from Hyderabad to Andhra Pradesh in Vijayawada, they have transported with some vehicle. Then where the complaint has to be preferred, it is a doubt. A police officer can register anywhere, because the forum part of the same transaction, the police officer who investigates, who finds a crime, they can register in any place of the offense, they can register the case. Likewise, suppose in a 323 IPC case, say for example, in a Shirdi village, 10th Street, at the house of A, offense was committed like this. A attacked B. Then complaint has to be lodged in the concerned town police station. Because Shirdi has got 2 police stations, for example. Rural police station consisted with rural areas, and the city police station consists with the city jurisdiction. If the offense is committed, because the offense is committed in the city limits, the city police or town police station has got right to register the case. Therefore, the complainant has to approach before the town police station. He cannot approach the rural police station to give the complaint. So, the complaint where the offense committed, there the complainant has to approach in the concerned jurisdiction. And regarding the court fees and all these things, I need not explain, because the stamp duty, and always you need not go for that. In a criminal cases, even for Wakalatanama, you have to go for advocate welfare stamp. Even for every other stamps, you have to put 1 or 2 rupee stamps like this. For that court fee, you need not bother about it. So under these circumstances, my dear friends, it is a very great fortunate moment for me to interact the first day session. And I'm very much thankful to the organizers who gave me this opportunity to interact with you. And congratulations to the organizers once again, who choosing me to be the evening day when a speaker of the inaugural function in this particular session. And once again, thank you very much, and congratulations to all the great personalities who watch this particular video through this particular organizing committee. Thank you very much. Thank you, one and all.
Thank you so much, sir, for such an enlightening session. It was indeed a great in itself. I would further request the participants, if you have any doubt, you can ask to the speakers directly. You may unmute yourself and ask to them. And although we are running late, so please be very short about it. Please go ahead.
Sir, good evening, sir.
Yes, good evening.
Sir, could you please explain once again that the case which you fought, like the NDPS case, that you explained that, because in NDPS case, the imprisonment is up to 6 months and 10,000 rupees. But you said that you use that Harnesh Kumar judgment. So could you please explain again, sir?
Yes, yes. In NDPS case, please go through Ranjit Kumar versus State of Andhra Pradesh first. Then you would get the entire information first. Ranjit Kumar versus State of Andhra Pradesh, and Harnesh Kumar versus State of Andhra Pradesh is a classic judgment. If the punishment is prescribed for up to 7 years, remember, if the punishment is prescribed up to 7 years, the 41A CRPC mandately, and they should issue the notice by the police to the concerned accused person. So they cannot arrest the accused. Definitely the police has to issue notice, and they should release the accused immediately. That is Harnesh Kumar versus State of Bihar judgment. So prescribed up to prescribed punishment, if the punishment is prescribed up to 7 years, the police has to issue 41A CRPC notice. Whereas in Ranjit Kumar versus State of Andhra Pradesh, this is another criminal law which I brought before the court. It is a new trend which I introduced to the court. In an NDPS case, if the punishment is prescribed, because this is some 500 grams, this cannabis was seized from my client. So punishment prescribed is 2 years. So when punishment is prescribed 2 years, section 20, different clauses cannot be forcibly registered against the accused. Therefore, in Ranjit Kumar, whatever it is, simple point is, if the punishment is prescribed up to 7 years, whatever the offense it is, you can easily demand the police to issue 41A CRPC notice. That's it. You please go through Ranjit Kumar versus State of Andhra Pradesh and Harnesh Kumar versus State of Bihar. These are 2 important classical judgments.
So after issuing the notice, one can easily avail the bail on bond.
Yes, yes, absolutely, absolutely.
Okay, sir. And sir, about 164, you said that their signature is needed. 164 confession.
Absolutely.
Okay, sir. Thank you, sir.
Okay.
Sir, if this police doesn't record the FIR and we, after investigation, and we report to SP, he marks the file to the same investigator officer, then what to do?
No, I'm not catching your point again. Sorry, you please explain.
Hello.
A complaint is lodged with the police. They carry
Yes.
out the investigation but doesn't record FIR. Matter
Okay.
is reported to SP, who marks the complaint again to the same investigating officer.
No, naturally, the SP will not instruct the same investigative officer. The SP instruct to the some other investigative officer. Suppose if it goes to the same investigative officer, then bias will be always. So therefore, you can approach directly under 200 CRPC to the concerned magistrate, and you can seek the remedy by way of filing of the private complaint.
Yeah, but SP had done that.
What SP has done, he has instructed to his subordinates to go for the investigation. Naturally, what the police will do when suppose see you have complained against the police officer to the higher officer, isn't it? See,
Yeah.
a sub inspector did not register your case. Okay, right? Then against that you have approached the police officer. Okay.
Yeah.
So therefore, the SP though instructs to go for the investigation, naturally the police officers always go for the bias. In such a circumstances, always doors are open for us under section 200 CRPC. You can easily to get your protection before the competent court.
Okay, thank you very much.
Sir, may I ask
Yes.
how to establish jurisdiction in the case of cheating case? If accused met somewhere else in the Uttar Pradesh, but he is living in the Delhi, and the complainant is office is somewhere else in Delhi, but living in the somewhere else, residence is somewhere else in Delhi. And our court is asking me to establish jurisdiction.
Absolutely, it's a right point. Very good point you have put, my friend. In fact, actually, it depends upon the various circumstances. Say, for example, see, in all cases, we can't say on one label, and all cases cannot be decided on one scale. Say, for example, if it is a fraud, suppose, for example, some people invites you to participate into some gaming activities, right? It is an online offense. Say, for example, in an online offense, you can't find the accused really, but simply you came to a conclusion that your money was transferred from the account of your, where are you residing now? For example, suppose, may I know where are you residing?
I'm residing in Delhi, sir.
Excellent. So in residing, suppose Supreme Court area, you are residing, for example. So you are deceived from the hands of somebody from Andhra Pradesh. So your question is where it is to be lodged. Simply you can lodge your complaint in Delhi. But the establishment of your ingredients and all these things depends upon various circumstances, my dear friend. One is documentary evidence, and number two is this online this communication and other things, and third one is this electronic and evidence and all these things. It depends upon the skill of the advocate and the complainant. You have to frame your own case. The counsel has to prepare that is why I have told you, minute details also should not be forgotten by the advocate to put into the writing. So therefore, the fixing of the jurisdiction, where you came to a knowledge, where you are deceived, where you are cheated, where you came to a knowledge, there you have to file a complaint.
Thank you, sir.
Okay.
Hello, sir. Is there any limitation period for filing a complaint? Because the victim may get traumatized, or the witness can get may get any physical injury. So, if there is any limitation
Yes,
period?
yes, ma'am. Actually, even suppose in rape cases there is no limitation, madam. Okay. In rape cases, there is no limitation. Even victim can lodge the complaint after 10 years, even 12 years also. There are classic judgments pronounced by the Supreme Court. Even because of the pressure, because of the threat to life, there is no limitation for some cases. But there is limitation for some cases. Say, for example, in a hurt case, suppose if A receives an injury, a simple injury, it is the duty of the complainant who receives the injury, he has to go to the police station directly. And it is the duty of the complainant, he has to approach the concerned doctor. But sometimes because of the threat in a whole village, suppose if they threat not to come out, then you can explain the things stating that because of this reason, I could not lodge the complaint. The proper and nexus, the perfect explanation with regard to the delay, if the delay is going to be explained properly, and that delay, if it is going to be accepted in the court, naturally your delay would be saved, madam.
In POCSO cases, sir?
Absolutely, there is no limitation. There is no limitation.
But many people are reporting after 15 years, 10 years, but the court is not accepting it.
No,
Any other reason for it?
see, after 15 years, madam, come on, you please take it as a granted how the case it is. We are not supposed to speak on the victims, this thing. See, after 15 years, 16 years, or 20 years, if a man comes up or if a lady comes up, you please test like that, because on this open platform, I'm not supposed to speak, because Karyeshu Dasi Karneshu Mantri Bhojeshu Mata Saineshu Ramba, because the lady, woman has a pivotal role in the society to discharge their duties. But sometimes we have to test it. We can't speak on a negative way against women, because I am bound to speak. I have more respect on the women, because please drop to ask, that question to get an answer from me.
Okay, sir. Thank you.
Sir, I have a question.
Yes.
Sir, does the superintendent of police have a discretionary power to extend a time period under the section 41A CRPC?
No. See, the superintendent of police has no role in issuing 41A CRPC. Superintendent of police has no role, because the concerned police has the concerned police station. See, kindly read it. Notice of appearance before police officer. The police officer in all cases where the arrest of a person is not required under the provisions of the subsection 1 of the section 41, issue a notice directing the person against whom a reasonable complaint has been made. The police officer means here not the superintendent of police. The police officer is the concerned police who has got charge in charge, that is station house officer or the sub inspector of police, the concerned, or the circle inspector of police. Suppose if the metropolitan, the concerned, sometimes the ACP also is the competent officer, but not the SP is going to be given any 41A CRPC.
What is the time period for that?
Yes, 7 days.
7 days. So one more question is there.
Yes.
If the crime scene was not allowed to visit, then what should the advocates do?
Before whom?
Before the police stations or police officers?
You know pretty well, my dear brother, as and when the accused is arrested by the police, the accused has got right to take the legal assistance, which is guarantee given by the Constitution of India itself. First, number one. Suppose if you are not allowed like this, you can file a petition, you can send a telegram to the upper authorities saying that police officer is not allowing us to like this, or else you inform to the concerned magistrate saying that in so and so crime the police is not allowing us to see this. You can put a complaint, or else you can directly file a writ petition saying that the police are calling my client without registering any case. You can take the protection from the apex concerned high court by way of writ of this thing.
Okay, sir.
Sir, I have one question regard to 41A CRPC.
Yes.
If I appear after a notice being issued under 41A CRPC,
Yes.
and the police arrest me saying that I was not cooperating, now how would I establish in court that I was cooperating? Because he has a certain, he can say that I was not cooperating. How will I establish that I was cooperating?
Please let me know. Please let me know in which offense you have to.
Supposedly, sir, under section 420 IPC.
Yes.
In cheating case.
Yes. In that particular case, you have to establish like this. See, for example, in a 420 case, the police is going, after issuing 41A notice, the police has to provide a time to you in that notice. Actually, you please go through that. I'm going to read out now because this is more important. Issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or such other place as may be prescribed in the notice. Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to notice unless for reasons. You please go through 41A class 3. Because
I have gone through that order also, sir, that judgment of the Honorable Supreme Court also.
Yes.
But many a times when they arrest, they mechanically, you all know how police at times work when they want to arrest. So practically, how would I establish in court that my client was cooperating, but for reasons best known to the officer, he has been arrested. Because if I don't appear in reply to the notice, he would certainly have an option. He would say that I was not complying. But if I appear, sir, and then for some reasons he said that I'm not cooperating, how would I establish that I was cooperating?
My dear friend,
Practically.
actually, you please bring before the notice of the concerned official about Arnesh Kumar judgment. I have dealt a number of cases before the High Court of Andhra Pradesh. I have brought to the notice of the Lordship's Court saying that the behavior of the police, in generally, what we are doing here is, without sending the accused to the police station in 420 case, we appear
Should we
before
apply
the court
for a bail?
Yes.
Should we apply
one.
for? Oh, okay.
Number one. Okay. Number one.
Sure.
Apply for a
Got
bail. Number two.
Oh.
Number two, you can straight away appear before the High Court saying that under 482 CRPC petition, criminal petition, saying that though it is a 420 IPC, though the case is fallen under the category of Arnesh Kumar versus State of Bihar, where the police has to respect the 41A CRPC mandate provision, still the police is threatening and canvassing that he intends to join with the hands of the complainant, and thereby you got it.
Got it, sir. Yeah.
Yes, I think you are satisfied.
Yes, sir, satisfied.
Good.
We should go with an interim protection from the court.
Yes.
Yes. Okay, sir. Got it.
Yes.
Thank you.
There is other aspect of this. Police may question this accused, but then they say, what are we asking? He is not cooperating with that question. He is not giving a vague answer, like happens in many political cases, and then they arrest him.
In relating to which offense, my dear friend, you are speaking?
Say, for example, this famous case of Mr. Advocacy, Minister of Delhi.
No. See, you remember. You please remember. See, practical is a quite different theoretical. Or a bookish or paper or opinions are quite different from the practical. See, in many ways, how the justice is being buried, we know pretty well. We are not supposed to speak on this platform. Let us discuss in another platform. You please relax yourself.
No, but let us not discuss that. But still, the police may have many power. They will say he is not cooperating, so let us arrest him.
Where are you practicing, advocate?
Yeah.
Where are you practicing?
Yeah, in Baroda.
Baroda, is it a district court or any high court?
District court.
So that is why you are getting some trouble. See, in general, you have to approach directly. Even if client doesn't have money power, he can refer the matter to the High Court by putting a petition saying that the police are not respecting, and you can give a telegram to the High Court saying that the State Legal Services Authority can intervene for the protection of the rights. Now we are dealing that cases. See, always oppression and suppression is always there. Rich and poor is always there. Haves and have not are always there. Akanksha, let us stop it.
Sir, before you conclude, on the 41A, sir, as you pointed out to read the section, may I proceed, sir?
Yes.
Yeah. So it is the last part of the section says, where such a person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may subject to such orders as may have been passed by the competent court. I think the police does not have the authority to arrest, but unless until he has the order from the competent court.
Yes, now you got my point. See,
yes, sir.
The police officer, in fact, unfortunately, we our people, we are supporting the illegal activities of the police. Okay, but in fact, unless the police officer takes the permission from the competent magistrate, he cannot take him into the custody.
I think that is what is 41 says, sir.
Yes.
Thank you, sir.
Okay, right.
So kindly give
Thank you to all the participants. This would be the last question. Please reminded we are already running late.
Because I have clients actually.
We don't want to give trouble to some. This would be the last question, participants. Please, we have 6 more days. Please be cooperative.
Sir, good evening, sir.
Yes, good evening.
I'm Kuldeep, sir, LLB first year student. Sir, as you said in Ranganatham Krishna Raju versus State of Andhra Pradesh case, we can directly file a anticipatory bail application to the High Court. Is it possible, sir?
Yes, absolutely possible without approaching the district principal, district and sessions court. Even a person, please go through the judgment which I quoted, and you can get the entire information without approaching the district court. We can approach directly to the High Court of Judicature for the granting of the anticipatory bail.
Sir, one more question. What is the difference between, sir, PIL and REITs? Sir,
I'm not catching your point.
Sir, what is the difference between PIL and the REITs?
This is a PIL is a public interest litigation which always
Yes,
affects the record, isn't it?
Yes, sir, but I'm little confused. So I asked you for the explanation. Hello, sir. Are you
I'm not
listening?
getting-
Sir, I'm little confused about this those like PIL and REITs. Both are filed under Article 32 and 226, right?
You're asking the difference between PIL and REIT, right?
Yes, sir.
Right. 1 minute. PIL, say for example, simple example, PIL is related to public interest in litigation. Okay, right?
Yes,
In your
yes, sir.
street, some mining mafia always carries flying number of vehicles which gives more dust and which injurious to the health of your area, for which number of people sustains more health problem. Then among them, anyone or the interested person or affected person can approach the High Court of Judicature for public interest litigation to restrain the flying of the vehicles which is injurious to you. Whereas REIT,
Yes, sir.
please stop your talkings.
So, okay, sir, I'll meet my in my side.
Right.
You can explain.
Thank you, one and all. Thank you, one and all.
Thank you so much, sir, for such an enlightening session, and thank you also for bringing the conceptual clarity by clearing everyone's doubts. We are also at the verge of ending this session. We, the team Legal Expatiate, express our deep sense of gratitude towards our guest speaker, Honorable Dr. Marji Suri Babu, sir, for taking your time out and for enriching us with your words, knowledge, and wisdom. This session is indeed going to help us a lot in our respective fields of litigation. We also thank to all the attendees for being so cooperative throughout the session. Thank you for being the part of this beautiful journey. And also we would like to have your presence for the upcoming session as well. One again, sir, thank you so much. It is always pleasure to have you around.
Thank you. Thank you so much. Thank you.